Hi, I'm Paul Pashy. Welcome to the Nell O'Connor Danielowitz webinar series. We're offering brief educational updates for our friends and clients. Today's topic is the new updates to the MSA reference guide that were issued by CMS earlier this month. Before we go into the updates, I wanted to briefly cover the background of what an MSA is for those who are unfamiliar with the term or just want to brush up on their knowledge. A Medicare set-aside arrangement or Medicare set-aside account is a part of a settlement of a workers' compensation or a personal injury case where funds are set aside from the settlement for the sole purpose of paying future claim-related medical expenses so that Medicare does not pay for them. Federal law requires that Medicare be secondary to any kind of insurance, including workers' compensation insurance and liability insurance. And the MSA is designed to provide a mechanism within a settlement, especially a settlement involving a Medicare beneficiary or a person who is expected to become a beneficiary in the near future, so that the funds are set aside to cover those future medical costs. And the reason this is being done is to adequately consider Medicare's interests so that after the settlement there aren't any issues where Medicare would come back and try to collect for payment of future medical benefits, either by going after the beneficiary or by going after the insurance carrier. So earlier this month, CMS issued version 3.2 of the WCMSA reference guide. And this includes the update that we're going to talk about today. One main difference between workers' compensation and liability law with regard to the issue of future medical expenses is that for workers' compensation, CMS has offered a formalized program for submitting a proposal that Medicare will approve. And the advantage of using this procedure is that if Medicare approves the MSA amount, then the parties are protected and have a written agreement from Medicare that it will not seek any further future reimbursements other than the funding of the MSA itself. The WCMSA reference guide is the handbook that CMS uses to review and approve proposals that are submitted by insurance carriers or claimants. The new change adds a list of major medical centers that will be used by CMS to come up with the cost that it projects for future medical treatment. This is different in the past where Medicare would use either the state medical fee schedule or the usual and customary pricing in states that don't have Medicare fee or medical fee schedules. So how this new process will be used is that for treatments involving surgeries in particular and extended hospitalizations, Medicare will look to the pricing used by the major medical center it has selected for each region of a particular state. And this pricing may differ greatly from what exists in the workers' compensation fee schedule for that state. But at any rate, it may also differ significantly from the actual medical providers involved in the beneficiary / claimant's case. So in Illinois, we do have a medical fee schedule. And for workers' compensation cases, this is going to create a bit of a conflict in situations where the Illinois fee schedule provides a lower cost pricing than the assigned major medical center. And for example, in Chicago, I've done some quick spot checking on the cost of an arthroscopic surgery for a knee. And under the Illinois Medical Fee Schedule, the pricing within the city of Chicago or Cook County comes to approximately $12,000 for that surgery. But using the major medical center pricing, which is based on a particular hospital on the south side of Chicago, the pricing average comes out to be closer to $18,000. And this is a relatively common procedure in work injuries, but it's also at the low end of the spectrum. And so we're expecting that there will be some controversy as a result of this amendment to the CMS manual, where we're going to need to work to convince CMS to accept lower prices, or else in the alternative we're going to have to live with the higher pricing in cases involving future surgeries. So what else can we do in response to these amendments? One thing to always consider is that the MSA process, whether we're talking about the formal workers' comp process or the more informal liability case process, is always voluntary. There is no law that requires litigants to get an MSA. As I mentioned before, the benefit of getting one is that you get a written confirmation from Medicare that it agrees its interests are protected. However, even without that formal sign-off, by providing funds in the settlement specifically designated for future medical care, and by having those funds based upon an objective analysis of the evidence in the case, the liability issues, and the actual future medical treatment that has been recommended, there is a strong presumption that any attempts by Medicare to collect for future reimbursement would be overcome by the fact that these funds have been set aside, assuming that the settlement funds were in fact used for that treatment. And all of those things can be set up in the settlement process without necessarily having Medicare sign off on it. In addition, sometimes cases can't be submitted. At the present time, Medicare does not have a formal system for approving liability Medicare set-asides. In addition, they have set review thresholds and will only consider certain workers' compensation cases that fall within those thresholds. So if you can't meet the threshold, then you can't submit your case for approval. In addition, in the majority of cases, it's not recommended that a submission be done anyway. CMS uses kind of a cookie cutter approach. Beyond the pricing that we've already talked about, Medicare has a rigid and inflexible approach to deciding what treatment is to be included and what treatment is to be excluded from an MSA life care plan. And often their inflexible approach does not match the evidence. And we have seen CMS attempt to include treatments that were not specifically recommended by treating physicians, or to include a number of future treatments such as physical therapy visits, physician visits, that go above and beyond any realistic expectation based on the objective evidence in the case. So for situations such as those where there are legal disputes of causation or medical necessity that make the CMS approach completely untenable and would otherwise prevent the settlement of the case, then there are things we can do, alternatives to avoid the MSA process altogether, which would thereby avoid these amendments to the MSA reference guide. First thing to consider is that there is a rule in the reference guide that we refer to as the MMI rule, which states that an MSA is not necessary under the following conditions, because when all three are true, they indicate that Medicare's interests are already protected. A, the facts of the case demonstrate that the injured individual is only being compensated for past medical expenses, B, there is no evidence that the individual is attempting to maximize the other aspects of the settlement, such as lost wages and disability portions of the settlement, to Medicare's detriment. And C, the individual's treating physicians conclude in writing that to a reasonable degree of medical certainty, the individual will no longer require any Medicare-covered treatments related to the injury. In many cases, these three criteria are easy to meet, and there are opinions in the treating medical records that conclude that the claimant will no longer need future medical care related to the injury and therefore will not require Medicare-covered treatment related to the injury. If you can satisfy all three criteria, then with or without a submission to CMS, you can show that you've complied with CMS's own reference guide and that no set-aside would be necessary for that case. However, if you have a situation where there is evidence that some future medical is needed, then a non-submitted MSA may still be not only viable but recommended to first of all show that Medicare's interests have been considered, but secondarily to enable the parties to rely on the objective medical evidence, to rely on the liability defenses, to rely on controversies where physicians may disagree on the specific nature of the future treatment, to reach a compromise that more fairly represents the realistic liability of the employer or the defendant with regard to the claimant's future medical. And then lastly, an alternative approach where the issues are in such a high degree of controversy that there's no realistic way to objectively quantify the future medical, compromise settlement contract language or settlement agreement language can contain explicit terms demonstrating the nature of the controversy and how Medicare's interests have been protected in the compromise agreement between the parties. All of these things involve a careful examination and analysis of the facts of each individual case. And this discussion was designed to give you an idea of what these new changes are and how they may impact handling of your workers' compensation or civil liability matter. If you would like a free assessment of your claim, please contact us anytime, and we would be happy to provide our insights and recommendations for your particular situation. Thank you, and we'll see you at the next webinar.